Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court Constitution Bench has overturned a three-judgment judgment in matter concerning to Asian Resurfacing, wherein the life of a stay order was limited to 6 months. The bench has ruled that there cannot be an automatic vacation of stay orders as laid down in the dictum of Asian Resurfacing of Road Agency versus Central Bureau of Investigation. The five-judge bench headed by C.J. Chandrachud and also comprising of Justice Abhay S. Koka, Justice J.B. Pardiwala, Justice Pankaj Mittal and Justice Manoj Mishra has overruled the ruling in which it was held that all stay orders in criminal as well as civil proceedings would be valid only for 6 months unless specifically extended. The Supreme Court has upheld a Rajasthan rule which mandated that candidates with more than 2 children will be ineligible to apply for government jobs in the state. The court dismissed a petition challenging the Rajasthan government's 2001 regulation which prevent a candidate from applying for a public position if he or she has more than 2 children. The court referred to its own 2003 order which held that the classification which disqualified candidates for having more than 2 living children was non-discriminatory and intra-vires the Constitution, since the objective behind the provision was to promote family planning. It should be noted that Rajasthan is not the only state that has a 2-child policy for contesting local body elections and for government jobs. The legal question pertained to the liability to deduct tax at source under Section 194H of the Income Tax Act 1961 on the amount to be earned by the distributors or franchisees of BAL by selling the prepaid coupons and SIM cards to the consumers. The Income Tax Department had claimed that the profits earned by the distributors is a commission payable to an agent by the SSC's telecom firm under the franchisee or distributorship agreement between the SSCs and the franchisees distributors. The Constitution vests the power to impose a tax on mineral rights not in Parliament but states. The Supreme Court told, underlining that such authority should not be diluted. A 9-judge constitution bench headed by C.J. Chandrachud, which was considering whether the royalty collected by the centre on mining leases can be considered as tax, as held by a 7-judge bench in 1989, said Parliament can only impose limitations to ensure that mineral development is not impeded. It said in respect of entry 50 of the list 2 of the 7th schedule of the Constitution, what Parliament can do is impose restraints, but it cannot say it has the power to impose a tax and states don't have it. The 7th schedule of the Constitution specifies allocation of powers and functions between the Union and states. Power to impose tax is not given to Parliament at all, it is not only given to the states. But in the interest of mineral development, Parliament can say you cannot tax in this manner, or for instance, tax should not exceed say 20% because if you do impose tax in certain way, it may impede mineral development. Now let's have an overview of High Courts. Observing that no differentiation is permissible between regular and contractual employees on the question of a woman's right to childbirth and maternity leave, the Calcutta High Court has directed the Reserve Bank of India to compensate an executive intern. Justice Raja Basu Chaudhary has observed in his judgment that on the question of a woman's right to childbirth and maternity leave, no differentiation is permissible between regular and contractual employees of the bank. The court directed the lead bank to give compensation to her in the form of leave with pay for her period for which it was denied. Noting that the RBI ordinarily provides maternity benefits to its employees as per its master circular, the judge said no non-extension of such benefits to the petitioner, in his view, constitutes discriminatory act as the same seeks to create a class within a class which is not permissible. The court said that this is violative of Article 14 of the Constitution of India. Denial of grant of maternity leave to the petitioner constitutes a discriminatory act and is an offence within the meaning of the Maternity Benefits Act. The Delhi High Court has held that once a party provides the wrong address, it cannot raise the issue of invocation notice of arbitration under Section 21 of the Arbitration and Conciliation Act 1996 being not served to the correct address. The single judgment of Justice Rekha Palli agreed with the petitioner and allowed the petitioner under Section 11 of the Arbitration and Conciliation Act seeking the appointment of a sole arbitrator for adjudication of disputes that have arisen between the parties concerning partnership deed. Learned counsel for the respondent accepted the notice. However, he opposed the petition as being premature by contending that the petitioner had failed to serve a valid notice in terms of Section 21 of the Act, which is a precondition for invoking arbitration under Section 11 of the Act. The single judge bench of the Jharkhand High Court has held that a woman is entitled to live a life in the similar manner as she would have lived in the house of her husband, that is, where the status and strata of her husband come into play, and that is, where the legal obligation of the husband comes prominent. The court observed that the inherent and fundamental idea of Section 125 CRPC is to compensate women for the mental anguish and sorrow they experience when forced to leave their married home, in addition to improving their financial situation. In order for her to support herself, the legislation stipulates that there must be some sort of acceptable agreement. The sustenance does not mean a mere survival. It was furthermore observed that when a woman is forced to leave her matrimonial home, she shouldn't be permitted to travel around making arrangements for her own needs or believe that she has fallen from grace. The division judge bench of the Jharkhand High Court has held that if a person in the heat of a movement on a sudden quarrel picks a weapon or anything which is handy and thereby injuries are caused, one of which proves fatal, he would be entitled to the benefit of this exception 4 to Section 300 of the IPC, provided he has not acted cruelty. It was furthermore observed that our legislature used two distinct terms, intent and knowledge, and distinct penalties are stipulated for actions carried out with the intention of causing bodily harm that is likely to result in death, and for actions carried out knowing that their actions are likely to cause death without intending to cause such bodily harm that is likely to result in death. Therefore, it would be appropriate to conclude that the intent and knowledge cannot be interchanged. They imply distinct ideas. In certain cases, if the outcome is so clear, it is possible to assume intent based just on the available information. It will not, however, imply that knowledge and intent are synonymous. The Madras High Court has ruled that power of suspension is not a punishment and is an ad interim measure, and if one has to be issued with show cause notice, then the very purpose of ad interim suspension is lost. Therefore, the requirement of issuance of show cause notice cannot be read into a provision of ad interim suspension. The court opined that mere conferment of authority on IBBI and IPAS for supervision, control and disciplinary proceedings by itself cannot be held to be conferring or unbridled power. The regulations and bylaws which are framed under Section 204 of the IBC clearly provides checks and balances. The procedure for taking disciplinary action and the appellate remedies are provided. Therefore, it cannot be said to be confirmation of excessive or unbridled power. Accordingly, the constitutional validity of Regulation 23A provision of Chapter 3 of the Insolvency and Bankruptcy Code 2016, more particularly Section 204A, B, C, D and E of the Act was upheld. The single judge bench of the Andhra Pradesh High Court has held that irrespective of the length of the delay, if there is sufficient cause for the delay, the same can be condoned. Therefore, in each case, the petition taken supported by evidence shall be considered to examine whether the petition can establish sufficient cause for the delay. It was furthermore observed that in the particular case, medical record only shows bed rest for only 1 month and no reason was shown for her inability to attend for the rest of the period. It was thus noted that when there is an unexplained long delay, it cannot be condoned to the prejudice of the interest of the contesting party merely by stating that it is in the interest of justice. The Delhi High Court has held that the natural consequence of the investigation for a period beyond 365 days not resulting in any proceedings relating to any offence under the PMLA Act in terms of Section 8(3) of the Act is that such seizure lapses and the property so seized must be returned to the person from whom it was so seized. The issue for consideration was the meaning of the two words, the proceeding relating to the any offence under this Act before a court in Section 8(3)(a) of the Act. The bench opined that for ordering a provisional attachment of the property proceedings in the form of report under Section 173 of the CRPC or a complaint for taking cognizance of a scheduled offence is a prerequisite. It was ruled that the words proceeding relating to any offence under this Act appearing in Section 8(3)(a) of the Act means only a proceeding that is pending before a special court in relation to the property or records that are attached or seized or frozen or with respect to the person for whom such property was seized or recovered. Moving on to international news this week. NSO Group, the maker of one of the world's most sophisticated cyber weapons, has been ordered by a US court to hand its code for Pegasus and other spyware products to WhatsApp as part of the company's ongoing litigation. The decision by Judge Phyllis Hamilton is a major legal victory for WhatsApp, the Meta-owned communication app, which has been embroiled in a lawsuit against NSO since 2019, when it alleged that the Israeli company's spyware has been used against 1,400 WhatsApp users over a 2-week period. NSO's Pegasus code and code for other surveillance product it sells is seen as a closely and highly sought state secret. NSO is closely regulated by the Israeli Ministry of Defense, which must review and approve the sale of all license to foreign governments. Pakistan's Supreme Court has defended its top judge after a ruling he issued related to blasphemy that sparked an online backlash and led to three-wheel death threats. The campaign targeting Supreme Court Chief Justice Qazi Faiz Issa began after he ordered the release of a man from the Ahmadi religious section considered heretical by hardline Muslim scholars. The man had been accused of disseminating a forbidden Ahmadi text, which firebrand clerics considered tantamount to blasphemy, a hot-button issue in Muslim-majority Pakistan where even unproven allegations of offending Islam have sparked violence. The United States Supreme Court has announced that it would hear the case of Donald Trump, who claims that he has absolute immunity from prosecution in the criminal investigation into his attempts to overturn the 2020 election results. This decision could delay the trial until the 2024 election. The court scheduled oral arguments for the week of April 22nd to review a recent ruling by a 3-judge panel of the U.S. Court of Appeals for the D.C. Circuit, which strongly denied Trump's immunity claim in a decision earlier this month. In the end, we have miscellaneous news. The Supreme Court has issued notice in a petition filed by 21 people seeking direction to constitute a special investigation team of the Central Bureau of Investigation (CBI) to probe the alleged nationwide scam by popular motivational speaker Vivek Bindra and his company Bada Business Private Limited. A bench of Justice M.M. Sundaresh and Justice S.V.N. Bhatti issued a notice to the Center, CBI Enforcement Directorate and 12 states to file their response in 6 weeks. The petition was filed by Shubham Chaudhary and 20 others claiming that they had deposited their hard-earned money in the money chain-linked scheme of Bada Business Private Limited. It sought action against Vivek Bindra and Bada Business Private Limited for duping and cheating the public at large. Calling Vivek Bindra a self-declared motivational speaker, the petition said that the Bindra and his marketing team deceived thousands of youngsters from across India. The Delhi High Court has sought a response from the centre on a petition challenging a notification issued by the Ministry of Housing and Urban Affairs relating to the use of maiden names by married women. The petition stated that the said notification mandated that if a married woman wishes to obtain a maiden surname, she will have to submit a company decree of divorce or an NOC certificate from her husband that he has no objection if she uses a maiden surname and has to submit a copy of identification proof and mobile number. The petition further alleged that the impugned notification is patently discriminatory, arbitrary, unreasonable, and violates the petitioner's fundamental rights under Article 14, 19, and 21 of the Constitution of India. For such reasons, it deserves to be quashed at the outset. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.